On behalf of the Federalist Society, it is my great pleasure to welcome you all to our national conference on the subject of civil justice in the litigation process. Do the merits in the search for truth matter anymore? By now, all of you should have received a copy of the conference's program, which contains a schedule of panels for today and tomorrow. If you have any questions during the course of today's proceedings, we encourage you to approach our staff out near the registration tables. We had originally planned to have Senator Spence Abraham from the U.S. Senate deliver introductory remarks today about the conference and the subjects to be discussed here. He had a family emergency that had to be taken care of this morning, and we are told that he is going to make every effort to come by here later this morning. So the plan is to proceed with this morning's panel, and at some point during an appropriate break in the conference when he arrives, we'll just fit him in, which is the least we can do for a U.S. Senator. We'll begin this morning with our panel on class actions, and the moderator for this panel is Mr. Max Boot of the Wall Street Journal, who many of you probably know from his writings on various civil justice issues in the Journal and elsewhere. Mr. Boot, thank you.
I'll keep my opening remarks mercifully brief, and hopefully we'll get to the panelists fast and then to a good discussion. Our topic today, as I'm sure many of you are aware, is class actions, useful litigation device or tool of the devil. We have both sides represented in this debate, which is convulsing the American legal system and has been for a number of years. And I'm sure if we can just convince our panelists to overcome their natural inclination to be polite and respectful towards each other's viewpoints, we'll have a wonderful, engaging discussion here. I'm sure this audience needs little introduction to the history of class actions, which were, of course, their modern history, of course, dates from the revision of Rule 23 of the Federal Rules of Civil Procedure in 1966. And the authors of that revision, or so they say, had little idea of what they were unleashing on the world. They rewrote Rule 23 to make it easier for Southern blacks to win injunctive relief against Jim Crow segregation. Instead, what they created was a seemingly endless line of cases that have enriched many lawyers, clogged many courtrooms, and occasionally even delivered a few dollars for plaintiffs. The use of class actions obviously has been tremendously controversial, and I guess there's two main categories of criticism that are made. First, it is argued that class actions are inherently incapable of dealing with mass torts. Indeed, the drafters of Rule 23 in that famous note pretty much said that. Not only are class members' interests too divergent to be tried in one setting, but certifying a class often puts a gun to defendants' heads and forces them to settle even cases that are largely meritless. For these reasons, various appeals courts, including, of course, the Fifth Circuit, which we have represented here today on the panel, have been decertifying tort class actions, most recently in the Castano case. Many of the appeals court's fears about what class actions can do in a mass tort context, I think, were confirmed in the breast implant case, where Dow Corning went bankrupt despite joining a global settlement and despite the fact that to this day there is not a shred of credible scientific evidence that the company did anything wrong, which is, of course, a viewpoint that I'm sure some members of our panel will disagree with. The second common criticism of class actions is that they're driven more by the needs of lawyers than plaintiffs. Indeed, in many cases, and I have in mind here the airline price-fixing settlement or the America Online settlement, which was just recently reached, many of the class members aren't even aware of what's going on because of the opt-out device, which courts usually take to mean that you can always certify a class action just as long as the members have the option to opt out. And of course, I'm sure all of you lawyers in this room carefully read all those fine print notices you get in the mail and carefully read those ads in the back of newspapers, but I think that I don't and most average people don't. So we have no idea of what is actually happening when class actions are certified, and we certainly don't choose to exercise our right to opt out because the stakes for the individual are so tiny. It's just not worth it. Nevertheless, the lawyers can go ahead and certify the class and, of course, reap millions in fees from representing these unwilling plaintiffs. And I think a pretty good, well, the most extreme example, the one I like to always cite, is the Bank of Boston case, where the bank deposited up to $8.76 in each class member's account. But to pay $8.5 million in lawyers' fees, the bank then withdrew upwards of $90 from each account. So in other words, the class action wound up costing the plaintiffs money. Incidentally, before turning to the panelists, I should note that class actions is really not an issue that always pits plaintiffs versus defendants and always pits plaintiffs' lawyers versus defense lawyers. Many defendants embrace class actions as a way to limit their liability. We saw that with the Georgine settlement, where the asbestos manufacturers went out and struck a deal with Ron Motley and Gene Locks because they wanted to settle 100,000 future claims. And conversely, many defense lawyers, and including many of the Naderite people, say that they often oppose these class action settlements because they shortchange the rights of individual plaintiffs in favor of their class counsel. That's about all I'm going to say on the background of class actions. I think you're much more eager to hear from the panelists. Our first panelist is a distinguished member of the Fifth Circuit Court of Appeals, and he also occupies a large place in class action history. He was the author of, among other opinions, the 1990 Fiber Board opinion, which decertified an asbestos class and eventually paved the way for the decertification of the Castano class this year by the Fifth Circuit. Now he's presiding over the Judicial Conference's committee that's rewriting Rule 23, an effort which may not get much ink in the popular press, but it is hotly controversial in the legal world. It's witnessed the formation of the so-called Steering Committee to Oppose Proposed Rule 23, made up of various law school luminaries. I was telling the judge before we started that if he's opposed by everybody in the law schools, then he must be doing something right. I give you now Judge Patrick Hickenbotham.
Thank you very much, Max. I thought I would very quickly thumbnail what's on the plate from the rules perspective, without getting into a lot of the boring details of the rule structure, but in general to tell you what the approach to the rules process is. We have Frank Easterbrook's here from the Standing Committee, is very much a major player in these rules process and very, very familiar with all that I will tell you. And I tell you that so that you can get a chance to visit with Frank too about some of the details about the rules process. Very exciting, very interesting times that we live in. I think that before I turn to the immediate detail of what we're doing, make a couple of general observations that the Advisory Committee on Civil Rules and others have kind of slowly come to. A consensus, I think, that our view that in looking at class actions, it's very, very important to realize the limits that rules themselves have. That is, there are built-in limitations as to what we can do to attack a problem that is out there now by the use of the rules changes. And the reason for that is that much of what we're seeing is simply not the product of rules themselves, but they're the product of a very complex interaction of events. I think you can start with the Supreme Court's decision in Bates. When you turn lawyers loose to advertise, they treat them like shoe merchants. They may act that way. The open solicitation and the opportunity to build cases is part of the mix in which this phenomenon that we're now seeing arises. You add to that a tort law that is very much open-ended. It suffered mightily from indeterminacy, very difficult to understand and exactly what the normative limits and push of the products liability rules are, for example. Those of you who tried products cases know that. I've charged so many juries, you turn around and ask the jury, ladies and gentlemen of the jury, the first question you must decide in this case is whether or not the product was defective. And I instruct you the product is defective if its risk of injury to the public outweighs its utility of design. You got that? Now, if you've answered that question yes, then answer the next question. The next question is, was that defect a producing cause of injury? And if you answer that yes, then how much in dollars and order today would reasonably compensate the plaintiff? Now, the other instructions I give them are what they would be given would be matters of credibility and so forth. Now, that simply points up what is inevitably a difficulty, and that's the underlying indeterminacy of the substantive law itself. You then add into this mix the talk shows, the role of media, and you began to start to see the percolation, if you will, of this phenomenon. I think it is short-sighted to see the mass tort class actions as being simply the creatures of lawyers. Lawyers play a heavy role in it, but a lot of those lawyers are on the bench. A lot of them are involved in other projects. It is a process, it is a problem of several social forces. That said, the approach to the advisory committee has been to reach out and to do as much listening as we can, to meet and with plaintiffs' lawyers, defense lawyers, to listen to the debate and to try to learn as much as we can about this phenomenon. And we came forward with 8 proposals. This happens to be what we term the minimalist proposal. And I think it's more conspicuous about what the advisory committee did not recommend. Looking at what are called futures classes, we declined to, at this point, to address those by the rules, leaving those to development. The central proposal rests on the proposition that we need more appellate involvement in the development of the law itself. So it will provide a right of appeal for the party that loses the class certification decision. But the right of appeal is a petition for leave to appeal. The Court of Appeals need not grant it, but it will have they will write the party losing that certification decision may take that to the Court of Appeals. This will relieve some of the stress that's being pushed on mandamus concepts where the courts are heavily engaged in reviewing some of these now. But we think that's important. Today, the law of class actions consists very much of a set of legal cultures, if you will, and that revolve and oscillate around distinct substantive areas of the law. The law of class actions in the antitrust field is different than the law of class actions with securities law. The law of class actions with regard to discrimination cases is very different. You cannot back away from this interplay of substance and procedure. If you look at the securities field, the substantive law will determine the ultimate ability of these cases to be processed or to be aggregated. Fraud on the market theories, if you will. The elimination of reliance in specific cases are the vehicles by which these cases are aggregated. And then you turn to the antitrust field and you talk about passing on theories and other Illinois BRIC. Those cases, those substantive rules are the facilitators of aggregation, more so in the real world than the existence of this bare bone outline of Rule 23. So appellate review, very, very important. I'm not going to go through each of the other requirements. One of the other powerful suggestions that we're going forward with is to move away from the traditional approach of Rule 23 of quick early certification. The rules now urge district judges to certify early, quickly, and frequently that's pushed with soothing words that certify now, decertify later, redefine later. We'll all work out. It'll all be okay, Judge. Don't worry, etc. And that's been really the shift now. It has been the emphasis. The shift now is to wait. And that has to do with allowing some of the cases to mature, not to move so quickly to class certifications, et cetera. One of the other central features is to address the problem, which has already been Max Boot referred to, and that is the difficulty of screening out of cases in which the returns to the class are simply de minimis from those in which you do need a class action to deal with a large number of persons who've been injured by some common phenomenon. What I would describe, the coupon cases, if you will, in which attorneys make millions, and at least in one case, I think the returns to the individual class members may have been negative. Every time you sent in your notice and so forth, incurred the cost, it cost you money. Not exactly a win by any definition for a member of the class. Where the class themselves simply do not benefit, the class has become nothing but a vehicle to pay lawyers, and the sense was that the district judge should be armed with the ability to screen those out. On the other, the defined task, though, is that you don't want in that process to eliminate, because I don't think the committee is authorized to do so, the across the board elimination of consumer class actions in those situations where the Congress, which should be the ultimate determinant, has provided this particular remedy for that particular statutory wrong, then procedurally we can't undercut that. Correspondingly, we ought not to create an enforcement mechanism that the Congress did not create. So we don't think that district judges or other courts ought to have the power to lean back and to say that it is in the public interest that this proceed in the class to vindicate these public values. The definition of public value should belong to the Congress. That is come to be known as the just ain't worth it provision, and it's been the subject of a great deal of discussion. Settlement classes, I'll pause at this and stop at this point. I'm sure will receive a lot of attention. The proposals there are really quite modest. As I mentioned to you, we do not deal with which the larger and more difficult problem. I think the most difficult problem in this whole area of class action is the futures provisions, and I will subside at that point.
Thank you, Judge. Our next speaker is not only one of the leading defense lawyers in mass tort litigation, but also one of the nicest people on either side of these bitter fights. As head of the products liability department at Skadden Arps, she's represented Dow Corning in the breast implant litigation, American Stores in litigation over salmonella contamination of milk, and Georgia Pacific in cases involving water contamination. And incidentally, I might add, although she's a defense lawyer, she's hardly cut from the typical Federalist Society cloth, in that she assures me that she is a genuine, long-standing Democrat. I give you Sheila Birnbaum.
Thank you. I think before we even focus on class actions, we ought to look at the modern technology that has given us mass torts. When I first started practicing law, as many of you, we were talking out in the hall, there was still carbon paper. And if you had to make a mistake on a complaint or a pleading, or you just didn't change it because you had to do it on 12 copies. And could you just imagine having a breast implant litigation if you still had to use carbon paper? So word process, fax machines, and computers have given us a new world, and the bar has entered that world with the judiciary. What's wrong with class actions and mass torts? Well, the problem with class actions are manyfold. And one thing that has occurred in the last year and a half or 2 years is that at least the appellate federal courts have recognized that the courts have gone astray in certifying mass tort class actions. And the Third Circuit, the Fifth Circuit, the Sixth Circuit, and the Seventh Circuit have all taken very close looks at mass torts class actions and have decided that they are improper. Period. end in medical device litigation, in tobacco litigation. National class actions just don't fly. Why? Well, first, there is the conflicts of law issue. There is no way, in my opinion, that a court can certify a national class of anything in the tort area. Basically, the law of the 50 states varies in every way, and the nuances, as Judge Posner pointed out, even in negligence, make it impossible to have a class action if you believe that tort law is state-made law, which it is. And, in fact, the Congress had an opportunity to pass a federal products liability bill and failed to do that. That might have created some interesting issues as to whether that would overcome some of the class action issues that Judge Becker and Judge Posner and numerous other judges have alluded to in the last couple of years. So with conflicts the way they are, with state law dominating the tort area, unless there is a single factual issue, which doesn't take anyone anywhere, there is no possibility, in my opinion, if you follow a conflicts analysis, you can certify a national class action in mass torts. And I think the courts have come to grips with that and understand that, at least some of our appellate courts. But the plaintiff's bar is very creative, if nothing else. And so now, even in cases that I'm in that started out as national class actions, they're asking for state class actions. Judge, just give me a class action of all of the residents of the state of Florida, the state of Pennsylvania. And as you all know, after the Castano case was decertified, right on the tails of it, there was the beginning of a number of state class actions that were filed in state courts, not even in the federal courts. So class actions for mass torts are not going away, even with the kinds of decisions we have seen. They are just going to shift in focus to the states. And we will have a little less ability to know how these cases will go. In some states like Alabama, it's not inconceivable, in fact, it has happened on many occasions, that the class is certified before you're served with the complaint, without a hearing, without even having the defendant say, hi, remember me, I have something to say about this. There are certifications before the complaint is even served. That's totally outrageous. And it isn't a rules issue in those states because most of those states follow the federal rules. It's an application of the rules, which leaves so much in the discretion of individual judges. And I think that the bar and the bench are going to have to explore how we resolve these issues of the change in focus from federal class actions in mass torts to state class actions. Let me give you an example of what I think promotes litigation where there is no litigation or would be very little litigation, and this is happening over and over again in courts all over the country. A drug is used. Some adverse reactions come to the fore or a study is done. In this particular instance, a case now before the Ninth Circuit, a product called Furbital. There are some Dear Doctor letters that go out or don't go out. Next week, there is a class action filed. On whose behalf? On all the users of this particular product. And that's exactly what happened in the Valentino case. And the class was certified. That is the class. All users. Not all users injured. Not all users who have a plastic anemia, which is the alleged illness. All users. Why? Because these people may be entitled to emotional distress. They may be entitled to medical monitoring. And you're off to the races. And the issue then begins to escalate. We'll see what the Ninth Circuit does with this case. It's now before the Ninth Circuit. But you have what really becomes mega litigation before there is any litigation. In this particular case, the case was certified before there was one case filed against the company as an individual case in the entire country. But now all users are part of a purported class. Part of the problem, one thing I would like to raise that was just raised by Judge Sheila in the Norplant case, which is interesting. If courts are going to make decisions about class actions later in the process, we cannot lose track of the fact that under the Supreme Court's U.S. Pipe case, the statute of limitations stopped all through the country during the time period that the class action has been brought and the certification decision has been made. In some instances, like in breast implants, where a class action had been certified very early in the Northern District of Ohio, which of course was later, much later in American Medical, overruled by the Sixth Circuit, there was no statute of limitations running for the entire period that case was out there. So there are ramifications in not deciding class actions at a very early time. What do these kinds of class actions lead to? They lead to legalized blackmail, as Judge Posner said, quoting from Judge Friendly, who is not a fly-by-night legal scholar. And why does it do that? Well, you know, my friends on the plaintiff side said, look, you're settling these cases because there's merit to these cases. That's ridiculous. You don't necessarily settle cases because there is merit. One cannot forget about the environment we live in. The market, the stock market, the uncertainty of a contingent liability standing over the head of a corporation, the effect it has on its borrowing, the effect it has on all of its business entities when it, like a Dow Corning, is facing thousands of lawsuits that may not have any merit. The company wants to avoid the contingency and move on with its life. And that's why we have settlements, and that's why the bringing together of these torts under a class action creates the kind of incentives that plaintiffs' lawyers want and that corporations have to face and are very problematic. Now, there are no free rides. When companies pay out all of this money, somebody pays a price for that. We do not have raw materials in the medical device area in this country. It is drying up because raw material suppliers were brought into these cases when there weren't enough defendants or even when there were enough defendants. Even in breast implant cases, not only were the manufacturers brought in, but all the raw materials of suppliers. What was the result of that? DuPont, Dow Corning, all of the major companies that supply medical equipment, not equipment, but medical products that make all the products we have, pacemakers, need silicone pacemakers. All of these products now, they are scrambling to get raw materials because the large companies make no money from this as compared to all their other products. Dow Corning never made any money from breast implants, did it because doctors wanted them to do it. And in the end of the day, they have this potential large liability that even if they don't pay for, they have legal fees that can run into the hundreds of millions of dollars, if not the millions of dollars. So I'm going to stop because I'm sure the plaintiffs' lawyers on this panel will have a lot to respond to. But I would end by saying that class actions in the mass tort area should not move forward.
Thank you, Sheila. I think that's about as forceful a statement of that position as we could hope for. Our next panelist, of course, is going to tell you precisely the opposite. We have a representative with us from Lieff, Cabraser in San Francisco, which is one of the leading class action firms in the country.
I am not Elizabeth Cabraser. Elizabeth is in trial in a class action in Alabama in a case now this is true, involving hardboard siding, and they're going to have the closing arguments today. Some class actions do go to trial. We will find out what the merits are according to an American jury. Plaintiffs' lawyers are really like Bob Dole. We say, don't trust the government, trust the American people. Let the jury system tell you whether there are meritorious claims. When the class actions go to the jury, like the Apple case did, and they had a $100 million verdict, or like the Lincoln Savings case did, and we had $1 billion verdict, and like the Exxon Valdez case did, and we had a $5 billion verdict. The American people tell you what justice is. Class actions serve very important and useful functions. The first function is judicial economy. When you have thousands of people with the same claim, it doesn't make sense to have the same evidence going in over and over again with the same people deposed over and over and appearing again and again, and having different courts go through the same issues and perhaps come to inconsistent rulings. So class actions serve judicial economy. But even more important, they provide access to justice. Our justice system is not a system only for the rich and powerful. It is also a system for everyday Americans who need legal redress when they have been wronged. And class actions give them the opportunity, by allowing them to aggregate their claims and to fight rich and powerful corporations, because by aggregating their claims, they can hire the experts who can do the analysis that is necessary. In the discrimination area, class actions have had a tremendous impact. And I refer you to two cases. The Shoney's case, which was a race discrimination case against a restaurant chain, and the Wall Street Journal had an article about this a few months ago, talking about how Shoney's admitted that they had been discriminating, that the suit was really a good thing for them. It helped them turn around to bring African Americans into their workforce. It made them a better company, and they're now thriving, even though they paid $180 million in this race discrimination class action. Similarly, in the State Farm gender discrimination case, about 10 years ago in California, there were 1,100 State Farm insurance salesmen, and there was not a single woman. Well, that's not because women can't sell insurance. It's because State Farm wasn't hiring women to sell insurance. And after this case, where State Farm paid $260 million in a gender discrimination case, State Farm has changed its practices. And if you look at the employment workforce of State Farm insurance agents in California now, it's almost 50-50 male-female. And that case also had an impact on other insurance companies who looked at what happened to State Farm and said, it's not going to happen to us. And they started hiring women for their workforce. So class actions are actually good for the American economy because it prevents inefficiency and racism, and it deters conduct. Now, the judge mentioned the consumer case where the individual might not get a huge return, and that there's a concern that, this case is only for lawyers. On the other hand, you don't want companies going out there and defrauding individuals and saying, well, since they only have a $50 claim and it would cost them $1,000 to sue, they're not going to do anything about it. Now, we had a case involving light bulbs where the package said that this is the environmentally sensitive light bulb. It's the Eco Saver, and you paid twice as much as you paid for the normal 100-watt light bulb to get this environmentally sound light bulb. Well, the reason that it was environmentally sound was it only gave you 80 watts. And so you were getting less light and paying more. Now, no individual really is going to go out and hire a lawyer about that case. It just doesn't make sense. But that doesn't mean that the behavior of that company is appropriate and should be awarded. That suit should go forward. Now, what should happen in terms of the attorney's fees? That's another issue. In the California state courts, attorney's fees in those kinds of consumer cases generally apply for a lodestar award, and then the court takes into account whether there was a benefit conferred and whether there was risk, and if appropriate, gives a multiplier on the lodestar. So I'm saying courts have the right to approve attorney's fees, and they do, but meritorious suits should go forward. In terms of blackmail and the size of settlements, if a suit has no merit, fight it. Make the motion to dismiss. make the motion for summary judgment, knock it out. If a company pays $500,000 to settle a case, I can say, okay, maybe that's cost of defense. But when the accountants in Lincoln Savings paid $80 million to settle those cases, that's not cost of defense. That's because they did something wrong, and they are paying because of that, and that is appropriate because it will deter other companies from engaging in fraud. One of the reasons that the American securities markets are so effective is that people feel confident investing in American companies. One of the reasons they feel confident is because companies are afraid of engaging in fraud because of private class actions. Let me turn now to the mass tort area. With respect to the laws of the 50 states, there are two ways that the plaintiffs have approached this issue. One is to say that the laws don't vary much from state to state, and a court should apply the laws of all 50 states. And there have been 3 courts that have done this. One of them was my case, is the Cordis pacemaker case in Ohio. Then there are 2 others that have gone to trial. One is Judge Brimmer's albuterol case up in Wyoming, and the other is the case that Elizabeth has now, which is the Masonite case in Alabama. The albuterol case and the Masonite case show that it is possible to go to trial with the laws of 50 states, and you give the jury special interrogatories about various issues, such as, was the conduct reckless, or was it negligent? Did the plaintiffs prove it by clear and convincing, or did they prove it by preponderance, so that you can apply the various laws. Now, there is a constitutional issue about applying the laws of the 50 states. In Schutz versus Philip Petroleum, the Supreme Court said if you're going to apply the law of a state to a company, there has to be a nexus between that state's law and the company. And I think in the future, you're going to see plaintiffs bringing mass tort lawsuits in the home state of a major defendant and saying apply the law of that defendant, because the defendant can't anticipate that they should have to obey the law of their home state, and that will get around the problem of having the conflicts of law that was seen in the Castano case. But let me focus on the Cordis case now for a little while. Cordis was a case where the pacemaker manufacturer knew that their pacemakers were defective. They would stop working. There were 2 kinds of pacemakers. One that hadn't soldered in the holes in the back, and that caused short circuiting in the pacemaker. And another, they had a lithium bridging problem with the battery that caused the battery to stop and the pacemaker would stop. And yet they continued to sell these knowingly defective pacemakers to 3,000 people. And they were criminally indicted for this. Well, this is not the type of behavior that should be encouraged. So we filed a class action suit, and we did ask for the laws of 50 states to be applied. And we did have 3,000 people who participated in that, and we got a very substantial settlement. The plaintiffs' class members did get substantial awards, and they were very, very grateful, and many of them said, this helped us pay medical bills that we never would have been able to pay but for this class action. So if you eliminate mass tort class actions, you're not only going to wipe out some cases that have no merit, you're going to wipe out cases that have merit. And that's why I urge extreme caution in solutions in this area. You need to give judges the flexibility to have class actions in mass tort areas when it is appropriate. So in summary, if you want Americans to have faith in the judicial system, they need to believe that they have access to the courthouse, and the way to do that is to keep the class action in place.
Thank you. Our next speaker comes to us from those law schools, one of which I mentioned earlier. She's a professor at Stanford Law. She clerked for Justice Thurgood Marshall, although she got her law degree from although she teaches at Stanford, she got her law degree from my alma mater, I'm happy to say, Berkeley. And she's been writing a good deal on the impact of attorney fees in class actions, and that is indeed the topic she's going to be speaking on. Professor Janet Alexander.
I'm going to stand, if you don't mind. I'm a little more comfortable, and also there's a clock here, so I might be a little more disciplined. A few years ago, I wrote an article about settlements and securities class actions whose title was "Do the Merits Matter?" And ever since then, I've wanted to write the sequel, which I wanted to call "Making the Merits Matter." And that's what I'd like to talk about today, some procedural reforms for securities and consumer class actions. But I think it's important to take a structural and institutional approach where we look at what's actually happening in a particular type of litigation we're focusing on and figure out what it is that's causing the conduct of that litigation to deviate from what we think of as the normal or the ideal way that litigation should be resolved, and then fix that rather than taking the view that the problem is too much litigation or frivolous litigation or greedy lawyers, or that I don't think that leads to very helpful solutions. I want to talk about some reforms that are addressed to what may be the core issue in representative litigation, and that is the agency problem. When you have any litigation brought by a representative on behalf of people who aren't before the court, the issue is whether the lawyer's interests, the representative, and in this case the lawyer's interests, may diverge from the class. In securities cases, there's some evidence that cases settle without regard to the strength of the case on the merits. In consumer class actions, some of the other speakers have referred to some settlements that appear to provide negligible benefits to the consumer class members, but substantial fees to the lawyers. I think that there are two basic kinds of solutions to the agency problem. One is get a client in there to monitor the lawyer's performance, and the other is take steps to align the lawyer's interests more perfectly with the class's interest. In terms of getting a client in there, I think that that there is actually a possibility of doing that more effectively in securities class actions, because as a matter of fact, securities class actions don't fit the paradigm of class actions. We think of class actions as something that we do because there are a lot of little bitty claims that aren't individually worth bringing suit over. And although class actions empower people to bring such claims, the problem is that there's nobody with a stake big enough to justify monitoring a lawyer's performance. Well, in securities class actions, in fact, there are claimants who have big stakes. In fact, one study showed that the top 10 claimants account for about 35% of the total claims in securities class actions. So there are some big class members out there, and they are institutional investors for the most part. Now, institutional investors have gotten a lot of attention from academics and legislators recently in terms of trying to get them in to perform this monitoring function. They're kind of the answer to your dreams, if you're, or they appear to be, if you're interested in solving the agency problem, because they are big enough to perform an effective job of monitoring. And institutional investors' interests seem to be almost perfectly aligned with the public interest in the securities laws, in that they are big consumers of information about companies, and so they have a strong interest in maintaining a disclosure environment that's not tainted by securities fraud. And but on the other hand, they are investors. They make their money from investors, and so they have a strong interest in making sure that companies aren't paying high costs for suits that have no merit. And the recent Securities Litigation Reform Act provide some provisions for trying to get large investors involved in a plaintiff steering committee. I'd propose, this is the most radical thing that I'd propose today, and that is to have an opt-in requirement in securities class actions that would affect the largest investors. And for investors, it would set the threshold designed to pick off about the top 10 or 20 claimants in the class, and say those people would have to opt in if they want to be able to participate in the recovery. And if they opt in, they thereby signify their willingness to be called on to serve on a plaintiff steering committee, which would be an independent committee to monitor the conduct of the litigation, including the choice of the class counsel. The opt-in requirement would, first of all, identify potential members of the plaintiff steering committee, and it would also make the amount of damages more objective and more verifiable, because you would know the amount of damages for sure that were attributable to the large claimants, and you'd only have to have experts estimating the value of the claims for the small claimants. The second type of reform that I'd propose is a truth in labeling requirement. And that is that in consumer and in securities cases, let me just state it in the terms that you'd use in securities cases, that any settlement or judgment could be stated only in per share terms, not in an aggregate lump sum term. The primary reason for that is that when the class member gets the notice of settlement and has to decide whether to object to the settlement, whether to opt out, whether to file a claim, or whether to just sit and do nothing, the most important information you need to know is how much am I going to get out of this settlement? But that is information that the class members in securities cases do not have. All they know is the total amount to be distributed to the class. Usually they get some idea of what the attorney's fees might be, but they have no information about how many shares in the class or how many shares might claim. This information would also help the judge who acts as a surrogate to protect the class members in the fairness hearing. It would help the judge to evaluate the worth of the settlement. In addition, at least initially, this proposal would help promote settlement, because typically what happens is the plaintiffs say there are lots and lots of shares in the class, and the defendants say, oh no, there are hardly any shares in the class. Well, if they really believe those numbers, then if you were to settle on the basis of a per share claim, you would have a greatly expanded zone of agreement, because you could say, let's settle for $2 a share, and that would seem like a small amount to the defendants and a big amount to the plaintiffs. Now, obviously, at the end of the day, somebody's going to be surprised, but over time, people ought to learn to have their estimates be a little more accurate. Finally, I mentioned you could make reforms that would align the interests of the plaintiffs and the lawyers and the class, and those are reforms relating to fee awards. I'd propose that, first of all, there be no negotiation of fee awards until after the final approval of the settlement. And that rather than having one lump sum amount of settlement from which the attorney fees are deducted, that there be first an agreement or a judgment on the amount of the award that goes to the class, and that money all goes to the class. And then afterwards, there be an adjudication of the amount of the fee, and that would be paid directly by the defendant. And what those two reforms would do is that they would ensure that the defendant has an interest in presenting an adversary presentation on the fee issue. Because what happens currently is, on the fee issue, there's an acute conflict of interest between the class and the lawyers, because every dollar that goes to the lawyers doesn't go to the class. And yet that's the very point where there is no longer an adversary presentation, except there are some kind of quixotic folks who go around objecting to these. But I think it's unwise to rely on Larry Schoenbrunn to do everything. Then I would go further and tie the amount of the fee more directly to the benefit that's conferred by having the hearing on the fee award be held only after the close of the period for filing the claims. Because if you have a per share or per whatever statement of the amount of recovery, then once all the claims are filed, you know exactly what the benefit is that's been conferred on the class, and the fee can be determined in light of that. And the judge should be required in determining a reasonable fee to make an explicit reference to the proportionality of the fee to the benefit conferred on the class. Let me give just one example, and that is the Pentium chip litigation. That's a litigation that was filed after the discovery of the defective Pentium chip, and there's a controversy on whether there had been the settlement involved a replacement policy, and Intel had already announced a replacement that they would replace the chips, and I think unquestionably Intel would have been required by market forces to replace the chips. Now, at least the settlement, the class action required them to replace it and produce some improvements in the terms on which it was replaced, and possibly had an effect on the scope of the replacement quality. But what I want to we don't have to argue about that to get to the point I want to make about the fees. At the fee hearing, the fee request was based on expert estimates of the value of this settlement to the class that were based on the selling price of the Pentium chip times the number of people who might respond. And the estimates were from $1.6 billion to $160 million. And in light of that, the judge's award of a fee of $4.2 million seems very reasonable. On the other hand, it was reported in the legal press that 6 months after the settlement, only $230,000 worth of claims had been filed. And in light of that, the settlement would not be reasonable. So tying the settlement, delaying the hearing on the fee request until after the value to the class is known, and tying the value of the fee award to the class benefit is, I think, would be an important improvement. And I think that these reforms would be superior to a lot of the reforms that we've seen proposed legislatively, and would be, except for the opt-in requirement, could actually be adopted today by judges.
Thank you. Well, this was the part you've all been waiting for. Our most famous panelist. His official title is Attorney General of the state of Mississippi, but I think he's better known among the tobacco companies as public enemy number one. The man who started the current trend of states hiring contingency fee lawyers to sue tobacco companies to recoup their Medicaid costs. Although not technically class actions, the state Medicaid suits are broadly similar to the class actions that are being filed now in the wake of Castano at the state level. They're purporting to represent all these people who have been injured by the tobacco companies over the years. And I'm sure Attorney General Mike Moore will defend that case.
Thank you very much, Max, for that kind introduction. Good morning, everyone. That's how we do things down in Mississippi. I don't know if I feel like I'm in the hospitality judge state today or not, but I'm going to talk after hearing Sheila and hearing Max, and having read many of the wonderful things that he's written about some of my friends, Dick Scruggs and others in this room, and hearing him use the terms tool of the devil, and then the term was used, legalized blackmail. I know that I'm not involved in any of that. None of those things. My case is certainly much different than any of the things that are being talked about today, so I really don't know why I'm here. But I'm going to give you just a little update as what the group here at the Federalist Society has asked me to do, an update about the tobacco litigation where we came from, where we are now, and maybe where we hope to go. And it is a much different situation than any class action lawsuit. As Attorney General of the state, we have, as you know, various duties, and one of those duties that's paramount to me, at least, and I'm sure to my other brothers and sisters that are attorneys general around this country, is to protect the public health and to protect the public interest. The backdrop of this case is the awful, I guess, tremendous burden on the healthcare budget of this country, we think, caused by one industry, the tobacco industry. The estimates are anywhere from 15 to 25% of the total healthcare costs in this country are attributable to tobacco-related disease. There's probably not one person in this room today that doesn't have a loved one somewhere in their family that has not contracted or died from lung cancer or heart disease or emphysema. And there's probably not one of you in this room that doesn't know of a child or some other who has been died from either sudden infant death syndrome or some of the many other cancers we say are caused by tobacco-related disease. So it's a personal issue with many people in this country, but it's a professional and a public responsibility issue with the attorneys general of this country. We didn't just start working on this when it became the popular thing to do in the last couple of years. We began working on our case, at least in Mississippi, back in early 1993. I can assure you there was no one in my state, I mean no one, not my dad, not my mom, not my brothers and sisters or anyone that told me this was an advisable course of action to take on the tobacco industry. As a matter of fact, I remember the day we sued the tobacco industries, and my governor had a statement, basically I believe, Mike, I quote him correctly, he said, "What do you think about the Attorney General's lawsuit against the tobacco industry?" He said, "Makes me want to throw up." So I had support from my governor in this, and as you know, as attorneys general, one of the things that we have to do is we have to go to the legislature to get appropriations. So one of the things I did is go across the street 2 or 3 weeks from that point and ask my chairman, Chairman Capps, who is the head of the appropriation committee, for money to run my office. And of course, he had a cigar about this long at the end of the table, and he's a big smoker and plays in all the RJR golf tournaments, et cetera. And he says, "Mr. Attorney General, I don't want you to spend one penny on that damn tobacco lawsuit." And I go, "Well, what if we recover a bunch of money?" He said, "I don't want to hear anything about it." So I had tremendous support. And then the most horrible call I got was from one of my law school buddies who called me from New Orleans. He's another one of those awful, and Gerald, one of those awful plaintiffs lawyers that makes all this money and leaves these other people without anything. He called me up. He knew that I'd been a prosecutor and been involved in the drug cartels and things like that for 10 or 12 years. He said, "Hey, Moore, you ain't suing the cocaine boys. These are the tobacco companies." So I felt real good and steady and ready to go. And the last 2.5 years has been that kind of ride. I'm sure I've got a lot of friends out here in this group and supporters about this lawsuit. I recognize many of you from the law firms, and you really should say thank you, because I know how much money I have made you over the last 2.5 years. My friend Dick Scruggs told me earlier that you probably have all taken out key man insurance plans on me, because if I die, you're going to go out of business, many of you. But to the facts of the case, it is, in my estimation, and maybe not in some of yours, the most important public health litigation ever filed in history. The backdrop is that 420,000 people a year die from tobacco-related disease. It is the #1 preventable cause of death in this country. The facts are that 3,000 kids start smoking every day. And the facts are that 1 in 3 of those kids will die from tobacco-related disease. So from that standpoint, I couldn't think of a more important role for attorneys general or even lawyers to play in trying to protect the public's health. And you can argue, as the tobacco companies do, and I still can't believe it, that I've seen some of the transcripts from these smokers' cases. Cigarettes don't cause cancer, they say. And nicotine's not an addictive drug. I swear, remember that in 1994 before Congress? And we don't manipulate the levels of nicotine. But in the defense of these cases, they say, "But you assume the risk." Darndest thing I've ever seen in the law. We don't cause any injury, but you assume the risk. With that backdrop, what we began to take a look at in Mississippi, and frankly, we looked at the whole country, is the tremendous numbers, the cost to the public health fisc of treating tobacco-related people. And in our particular cases, primarily focused on indigent or poor people. In Mississippi, I know it's a small southern state, and we only have about 2.5 million people down there in Mississippi, but about 20% to 25% of the people in our state are on Medicaid. about 500,000, maybe 550,000 people as of this year on Medicaid. We have the highest incidence of heart disease. We spend in Little Mississippi about $100 million a year just treating poor people for tobacco-related disease. We can't afford that in Mississippi. When you multiply that number across the country, it's $6, $7, $8 billion a year. And then probably the most important piece, and I think you have even entitled your program, Does the Search for the Truth Matter Anymore? One of the things I think we've accomplished and will continue to accomplish in these cases is to expose the truth about the industry. There are 16 states now that have filed cases against the tobacco industry. We filed ours first in March of 1994. Shortly after that, 4 other states filed. The list is Minnesota, Florida, West Virginia, Massachusetts, Louisiana, Maryland, Arizona, Connecticut, Kansas, Michigan, Oklahoma, Texas, Washington, New Jersey, and Alabama as a little bit of a different case. Of those 16, and yesterday, New Jersey, if I didn't say New Jersey filed, 16 cases. Of those cases, there are different causes of action. Most of them have equitable causes of action that are involved in unjust enrichment, restitution, indemnity causes of action, public nuisance causes of action, and ask for injunctive relief. Other states have filed and added consumer protection planks, antitrust planks, some traditional tort theories. Others have filed in federal court. One state, Texas, has filed a federal racketeering action against the tobacco industry. So primarily 15 state cases, and yeah, it's funny until the end. 15 state cases and then 1 federal case have been filed. There have been significant events in the cases. In my own case, for example, not only am I facing the tobacco industry on one side, I've been sued by both the governor of my state in an attempt to, that's right, sued by the governor of my state in an attempt to stop our case. Also, the next day, the governor filed one day, and the next day the tobacco company sued to stop our lawsuit. We argued that last week before our Supreme Court. Other significant events that you've read about, frankly, whether it applies to the class action or not, or the whistleblowers who have come out. Frankly, I've never seen such a dodge to hide the truth in my life as from this litigation. I've also never seen such a misuse, and that might be an issue for another day, misuse of the attorney-client privilege and the work product privilege in these cases, as has been revealed probably more so by the documents, whether borrowed, stolen, whatever you want to call them, Merrill Williams from the Kentucky law firm, and the one who brought forth all this information about Brandon Williamson. The point of that is that it'll be hard for you to find a case, any tobacco case, where any of those documents have been turned over and discovered, even though they have been made public over the last 2 years. When Dick and I got those documents, we took them to the Justice Department and to the FDA and to Congress, and now I guess they're even on the internet. I point that out to you because I've heard so much criticism, read about it, Max, and heard so much criticism about lawyers and what they do. I think some of the shining examples of this litigation are what lawyers are doing in the search for truth. There's one thing that is always challenged in these cases, the contingency fee contracts. And Max, I read your article, your first case about Mississippi. I wish you would have called me about it. We don't have a contingency fee contract in Mississippi, even though the Wall Street Journal says that we do. And our lawyers will only get paid in our particular case if, should we win our case, and the court will award reasonable attorney's fees at that point. All the other states do have contingency fee contracts, and they do range from anywhere from 15 to 25%. The first case that will be tried is, we're set for trial March the 23rd of this next year. Our judge has declined to stay the action, even though the tobacco companies have attempted time and time again to have the action stayed. We think our case will be tried that day. Discovery is going very well from our side. We have turned over millions of documents to the tobacco companies. It's very slow from the other side. The other case is set for trial will be probably the next case, Florida. As you know, Florida not only has a very solid case, but they have a statute that was passed through the legislature, which has also been the center of some controversy and lots of litigation. I predict the next case to be tried after the Florida case will be the Texas case. So in 1997, I think you'll see the Mississippi case, the Florida case, and the Texas case, each a different type of case being tried. The next case that will be tried maybe in 1998, late 1998, will be the Minnesota case. I know I've taken probably more than my allotted time, but I'll be glad to answer any questions that we have, and you've read a little bit about some of the proposed settlements, even though there are so many protestations that we're certainly not talking to the Attorney General. We're certainly not talking to the Attorney General. The one settlement that we did have, the Liggett settlement, was the first time, as you know, any tobacco company has ever paid any money in any case. We recovered, looks like the settlement will be worth about $25 million from them. And lawyers, Max, didn't make any money out of those settlements. There have been no fees paid and will be no fees paid out of that settlement. So my lawyers are working pro bono. I don't know, Max, where you get the rest of it. Dick just left the room. Thank you very much.
Thank you, Attorney General Moore. Before we get to audience questions, I imagine there's probably panelists here who are just itching, dying, who've been sitting here for minutes and just want to jump in with something on what they heard. I think Sheila is one of those.
I'd just like to respond to my friend on the plaintiff's side. I get very disturbed when 6 people sitting in Cheyenne, Wyoming, or in any other place in the country is going to decide whether a corporation's existence continues or doesn't continue. It's not the American people that are deciding class actions if they go to a jury. There are 6 people sitting in some local courthouse that is deciding the fate of an entire corporation, or in some instances, an entire industry. That's a very different kind of thing. That's why corporations are afraid to put their whole corporate existence, because they're class actions. You have 100,000 people and then 200,000 people, or 1 million people that are going to be on the coattails of the representative plaintiffs, and you have 6 people in some local community making that decision. That's pretty scary, first of all. Second of all, with regard to the cases that were mentioned with regard to the issue of applying the law of 50 jurisdictions or in somehow having a trial, I know what happened in the Copley case in Cheyenne, Wyoming. And the case never went to the jury where there could have been a charge, and the judge never came up with the charge that was allegedly going to go to the jury. But what was going to go to the jury was the law of 3 different jurisdictions, because the representative plaintiffs had 3 jurisdictions that would apply, so they would have gotten different law in different jurisdictions. One jurisdiction had a statute, so the jury would have had separate law on negligence, strict liability, punitive damages, causation, and on top of that, the court thought it was also going to charge the restatement of torts 402A and a plain negligence charge. And then all people in states that had similar law were going to be bound, although there was no indication of what states that might have been. So it would be after the fact, some would be bound and some not bound. And Judge Rimmer even noticed in his fairness hearing, in the settlement of the fairness hearing, that there was a lot of controversy of whether this charge would have held up on appeal. So, and the Cordes case, which was mentioned, was really inferentially overruled by the Sixth Circuit in American Medical when they said that the 3 or 4 district court cases that had been certified, including breast implants and Dante, including Cordes, was really not proper class actions. So I still say you can't have a trial class, a national class in tort cases.
Judge Hickenbotham?
Yes, I think this discussion highlights a point that bears mentioning again, and that is that the problems that we're talking about are largely confined to one segment of class actions. Interestingly, when I hear counsel start to talk about mass torts, and then quickly shifted to the discrimination cases as the model of success. What we found in the course of our study in the rules process is that class actions have been working reasonably well. There are problems here and there and some serious problems here and there. But by and large, the legal culture that surrounds securities class actions and the forms that have been going forward have worked reasonably well. The discrimination model worked reasonably well. We find no mass tort cases, in fact, that have actually been tried. It doesn't happen. There may be some out there, but we've not located them as we define them. So the problem then becomes, we're talking not about the trial of mass tort cases, we're really talking about a narrow segment of what ought we to do with regard to settlement, if anything, of these large cases. I think it's also bears mentioning that it simply defies reality to deny the powerful effects of aggregation themselves. Let me just comment on the phenomenon, and then we can talk about how you respond to it. But as the General Moore knows, I'm bilingual. I grew up in rural Alabama, but I can talk as fast as the other slow talkers from the South. But down where when I was a little lad, we used to buy sometimes against my mother's counsel some firecrackers, and they were called by the politically correct, incorrect name then, lady fingers, and they were little tiny firecrackers about so big, and you could take them and hold them in your nail and put them up to the light, and they would fuse, and then you could hold them up and they would pop. We quickly discovered with my cousins that we could take about 30 or 40 of those lady fingers and peg rubber bands around them, and it'd blow your hand off. The aggregating effect. So on the one hand, with the class is proper, if it in fact, even though it may bring with it an interim and an extortionate type of effect, perhaps that's permissible if the class is of the type that you want to bring forward. On the other hand, what you don't want to bring forward are cases that gain their strength, not from the merit of the claim, but gain their strength by the aggregation itself. And that's one of the problems that the Rules Committee has been trying to get at, to separate out those cases. And for some time, we looked very seriously at insisting upon an inquiry as an element of the class certification into the merits of the class itself. We play with formulations such as that insist that there be some demonstration of likelihood of success, something akin to the injunction model, or something of that sort. And we seriously looked at it over a period of a long time and talked about it. And there was initially a lot of support for it across the board, but as time went by, we began to realize that the prices that would be paid for that were too large. And I won't take the time to go into that, except simply to remind people, and as we talk about this problem, I think it's very useful to talk about mass tort as being the problem and to recognize something else. There is an internal dynamic of the economics of the mass tort that do not exist elsewhere. These are not the creatures necessarily of lawyers. There's something else going on there. And part of that has to do with the phenomenon of the recurring patterns by definition of the mass tort, so that the economies of scale, once a lawyer such as a Ron Motley or Fred Barron has gained the information and the resources and all the mass discovery to maintain a single suit, he has then thereafter can deal with cases on a marginal cost basis, and they virtually can franchise out to other lawyers. And hence the economics of the structure itself, stemming from the patterned nature of the phenomenon we're talking about, a common product, a common disaster. That's what drives these cases, and that's one of the powerful contributions to aggregation of the economics themselves. Relatedly, our legal structure, which have, in the name of efficiency, pulled together through the MDL processes cases, and we've been very quick to pull cases from their moorings and send them to consolidate them before a single judge. And the last observation is to be very wary about extrapolating from the asbestos phenomenon. Asbestos drives in the background a lot of these mass tort cases, but very few of them are asbestos cases. In asbestos, they evolved to the point that the science is very clear. The cases become, as Francis McGovern would call them, essentially commodities, the commoditization of torts. Very experienced lawyers in asbestos cases can price those cases out incredibly and reach quick agreements on valuations. There are a different ballgame than you move to breast implants. I mediated the Ahern settlement, and I was involved in the mediation of the breast implant cases. They are very different you don't have developed science. You're dealing with very different sets of problems. And so I think it's a fundamental, my observation, Max, is simply one of definition, confining the kind of locate where the problems are so that we can begin to talk constructively about not necessarily solutions, but at least helpful approaches.
I think that's an excellent point. If I could just ask the panelists about a basic premise, I think, of what you, Judge Hickenbotham, were saying, and Professor Alexander and others, which is that the problems are really in the mass tort cases, and that the securities cases, now obviously Professor Alexander has some proposals on how securities and other kinds of financial cases could be better managed, but I think the underlying assumption is that these are basically meritorious cases. It's just a question of adjusting it and figuring out how to make it so that that the trial lawyers, the plaintiff's lawyers, don't get 99% of the benefits. They only get 60 or 70% of the benefits. Let me just ask the panel about the basic assumption, which is that these cases involve problems that are correct, that ought to be dealt with by the legal system and not by regulatory agencies, for example. And let me just cite you one case from Texas that I'm familiar with, involving a suit filed by John Kraken, an up-and-coming young plaintiff's lawyer there. He's suing Allstate and Farmers Insurance, charging that the companies have been incorrectly calculating their premiums for years through an obscure process known as double rounding. I'll save you the tedious details of what double rounding involves, but basically it's theoretically a small error costing each driver no more than $3.50 a year. But obviously, once you add up those $3.50 over 10 years, you get a $100 million lawsuit, of which Mr. Kraken obviously hopes to get $30 or $40 million. Now, assuming that he is successful in this, and he probably will be because it's been certified as a class in Beaumont or one of those other upstanding jurisdictions, what will the insurance companies do if they have to pay out $100 million, $50 million, $20 million? They'll raise their premiums, of course, to make up for that loss. So it's hard to see how the drivers will be better off one way or the other under the they'll be worse off under the suit. But my real point is that this is a case that involves an industry which is regulated rather strictly by the Texas Department of Insurance. And just as securities offerings are regulated rather strictly by the SEC, and there's regulations on what companies can say or do. So my question is, does it make any sense at all for the legal process to be attempting to rectify these $3.50 wrongs?
It absolutely does. The SEC does not have the time or resources to go after all of the potential or actual securities fraud. And in the Securities Litigation Reform Act, the legislative history of a rather conservative bill from a Republican Congress talks about the importance of private enforcement of the securities laws. It's absolutely essential. Let me address Professor Alexander's point about the securities area. The Securities Reform Act adopted many of her suggestions to some extent. For example, with respect to the client with the class interest, the Securities Litigation Reform Act says that there's a presumption that the investor with the largest financial interest will be the class representative, and that individual will, or group of persons will pick his or her client. Now, there are a couple problems with that. There have been about 100 suits filed since the Reform Act was passed. Only 2 cases have institutional investors step forward. And the reasons are twofold. One, the institutional investors are not interested in being involved in discovery. And 2, the loss is a relatively small amount of their overall portfolio. Whereas for an individual investor, for example, I have a case where there's a Marin school teacher who lost $40,000. It was almost 80% of her life savings. To her, it's much more important. It's a much bigger deal in her life than it is to the institutional investors. Now, I should tell you, I represent CalPERS, the Colorado Public Employee Retirement System, and the California State Teachers Retirement System in the California Microdevices case as local counsel. I think it's a good thing when the institutions get involved, but it's not going to happen very often. With respect to the truth in labeling requirement, that is also part of the new law. The new law says that the settlement notices now have to give disclosure on a per share basis. The problem with that is at the outset, you don't know how many people are going to submit claims. And since what you do is you take the amount of money that you have and you divide it by the number of claims that are submitted, you don't know what the per share award is going to be until the end. And so you have to give an estimate, which I think is what's going to happen in the settlement notices. But again, that's a good thing, and that's going to happen. With respect to attorney's fees, attorneys in securities cases generally apply for a percentage of the recovery, and the benchmark in the Ninth Circuit is 25%, which means that the class gets 75% and the attorneys get 25%. In the Intel Pentium chip case, Professor Alexander's numbers are a little off. It was my case, and the number of chips that were replaced was 1 million chips. And at a $500 per chip value, that has an estimated value of $500 million. The lawsuit, the first demand letter was sent on November 29th. The lawsuit was filed on December 2nd. Intel didn't change their policy until December 20th, and the court made a finding in the case that the lawsuit, although not perhaps the sole cause of Intel changing its policy, was a factor in Intel changing its policy. And the figure that you gave about claims had to do with out-of-pocket costs. In addition to the replacement of the chips, people who spent time rerunning programs also got money, and so that's in addition to the replacement of the chips. As to the issue of choice of law, I think it is cleaner to sue the defendant in their home state and try to apply their own law. That is absolutely cleaner. I think you will see that in the future. Mass tort cases, there are some mass tort cases where one case alone is an M80, and you don't get the power of it simply through the aggregation. And I think the answer is to give discretion to the district court judges. To some extent, it's like the pornography cases. They'll know it when they see it. And if you allow summary judgment to come before class certification, the really meritless cases are going to be dismissed on summary judgment before the class cert determination. But if it's a strong case and it can survive that kind of attack, you don't want to have the Cordes case where they pleaded guilty to a criminal charge of knowingly selling a defective product to not be certified, because that would deny access to the justice system to largely senior citizens who can't afford going out and spending hundreds of thousands of dollars on experts, which is what it costs to pursue one of these complex mass tort cases. A subdivision of the mass tort cases are the toxic spill cases. Maybe Your Honor differentiates them, but there you have to have a modeling expert to figure out where the air went or where the water flow went. The very expensive cases, people are harmed. You know, we did the Southern Pacific spill case in California where a toxic pesticide was dumped into the Sacramento River. No individual could bring that case. Only through the collective action can those meritorious claims be resolved.
And one thing that I think that should be emphasized and strongly, and that is who decides whether or not this particular social policy reflected by this statute it should be enforced, and that by these means. The assumption that people will go uncompensated, that people will not be, who've been wronged, will not be protected, rest upon the assumption that the protection that the statute is, as written, has accorded that type of protection to them. One of the problems with using Rule 23 as a trans-substantive type of a device is that it allows, it moves the decision-making responsibility for enforcement of these social policies from the Congress to the courts. And first, it is instigated and triggered by the lawyers, and understandably so. In those situations where the Congress has said that this is the policy and this is the way it's to be enforced, then I think it's very difficult to deny the legitimacy of this type of aggregation that's there. But in the situations where they have not made that that statement, or they've said something, or there's just no signal of that, then the traditional approach to reluctance to imply private rights of enforcement ought to take hold. So I think beneath the surface of this question of vindicating consumer rights lies the question, the familiar question of who decides, the familiar question of the allocation of power. Eddie Becker, I think, made a very vital point in the GM case, pointing to the underlying federalism concerns of an over generous reading of Rule 23, which can move these cases from state courts into federal courts. It is easy to say that we will dispense with the little nuanced differences among the state laws, but remember, those nuanced differences in the state laws are reflections of state policies. Whether Texas elects to go one way and Wyoming another way considered judgments of those states. And the price you pay for this efficiency is the step on those differences. Now, that may be permissible if the national interest in the Commerce Clause is so identified that you want consciously to step on those. In other words, this is a federal problem. It is a national problem. It ought to be approached that way. But then the question, who decides that? And I think that one of the lurking questions must be ultimately back to the Congress. In fairness to General Moore, if you say that you can't proceed through the private class action device, you're saying in part that lacks legitimacy and so forth. What you're saying is that the state, the elected officials who have legitimacy ought to be able to enforce those. And without having expressed no opinion about the tobacco litigation, but certainly attorneys general, where they have the statutory power to enforce that, have a much higher claim to legitimacy in enforcing those rights, one would say, on its face, than perhaps volunteer. At least the argument is made, can you have your cake and eat it too? Can you simultaneously say that you can't maintain these class actions, the lawyers can't maintain them in private enforcement, and nor can states, nor can the federal government, nor any other agency? Well, those are very difficult social questions, and my only point is not about the merits of them, but to simply pull those up a little bit and prick them up a bit so that we have in mind that what comes to us dressed as light little procedural issues quickly reach into very deep social judgments. And I think that's part of the perplexity that we see and that confounds many of us who struggle with these problems.
That's an excellent point. Are there people out there who want to pepper the panel with questions? Way in the back over there. Step up to the mics if you would.
Hi, my name is Joe Bellick. I'm from Public Citizen. I'm glad that you guys have a balanced moderator who doesn't have an opinion. And I'm glad to see that Max is now going to support all our efforts to strengthen the regulatory agencies as an alternative to tort litigation.
That's a different panel discussion.
Yeah. We're not used to having any time to talk to you, Max, so I figured I'd get that in. I was just curious if any of the panel would like to talk about Public Citizen's work on breaking up collusive class actions, where we've intervened now in over a dozen cases to go after the attorney's fees for plaintiffs, because we're concerned that the remedy for consumers is not large enough, and that the corporations are using a select group of plaintiffs' attorneys to basically create a settlement where the benefit to the consumer is small and the fee is large. We've done this more than any other group, and yet we continue to get attacked as being in the pocket of the trial bar. And I'm just curious if anyone would like to talk about this trend. In fact, Judge Hickenbotham mentioned Fred Barron, who's been working with us as one of the stalwarts to clean up this process so we can make sure the class action device survives and is not abused by a couple like Stan Chesley or a few others. But I think the consumer movement gets very little credit for intervening in these cases and going after both the corporations and the trial bar when these cases are settled like this.
I think Mr. Finberg, since you've been involved in some
That seriously, and it's absolutely inappropriate for attorneys' fees to get higher than the amounts that are given to the class. I absolutely agree with it. I think the consumer groups are to be applauded for taking an interest in that, and there should always be vigilance about attorneys' fees. I can say that in every case that we've had, the class members have always gotten more than the attorneys, and that's the way it should be.
Next question.
I've heard several of the panelists, more than one, mention an extortionate effect or an aggregating effect of sort of improper economic motivations. And I haven't heard a case of extortion mentioned all morning. We have the common law crime of exaction, which means someone was entitled to something before overreaching occurred. And we're confusing exaction and extortion. Extortion in the common law was where you were entitled to nothing and overreaching occurred anyway. And I said according to the distinction between extortion and exaction, because what we're really talking about is exaction, where something is due.
I can't be any more exact than I was.
Go ahead.
Thank you. This is for Mr. Moore. Good morning.
Good morning.
Mr. Moore, I'm really pleased that you're here today because I'm not a professional litigation attorney. I read about these tobacco lawsuits as an interested shareholder of Philip Morris, and I get most of my information from the Wall Street Journal. So as you know, it's pretty one-sided.
No. Accurate.
You mean you don't read the news columns?
Those stories are so long, you know. On the issue of your particular litigation, the issue that interests me, it's not about fundamental human liberty and the ability of an adult to make a choice thing. I'm really interested in it from the economic point of view. And everything I read about those lawsuits indicates that there is no economic cost to the government from tobacco-related deaths because people tend to die in their 60s just at the point where they're about to go on to Social Security. So that in point of fact, there's net savings. Now let me finish.
Thank you very much.
Let me finish the question. Of course,
My favorite issue.
nobody denies that it costs the smoker something, that smokers personally do something to themselves. But I want you to, I not only want to answer that question because I've never seen a response as to that. I only see that side of the analysis. But even if you're going to come back and say, yeah, it does cost Mississippi something for the part that the state pays out of Medicaid, I'd like to know, have you asked to Mississippi, just looking at the economic point of view from these cases, and is there any way to look at this where this would make a difference to you? Suppose the federal government picked up all of the Medicaid costs. Is there any way that economic analysis would have an impact on you that would make you stop that litigation?
Sure. I thank you very much for that question. It's the early death defense that I love the most that the tobacco companies have espoused. It's the only time in the first 3 hearings that our judge ever said a word or ever looked up. He never asked a question, never said anything. The first time that they brought that argument before the court, they said, okay, Judge, just assume for a minute that we do kill these people. Just assume. We're not saying we do because, you know, cigarettes don't cause cancer, nicotine's not an addictive drug, and we don't sell to children. But just assume that they prove that we do. They die early in Mississippi. We kill them early. Matter of fact, we kill lots of them early. And think about how much money, go look at the transcript, how much money we save the taxpayers of the state of Mississippi and the federal government because grandma dies early and grandpa dies early, and we don't pay Social Security anymore. We don't pay Medicaid and Medicare anymore. We don't pay retirement benefits, and these people don't earn anymore. And also, just think about the money that those doctors make and the taxes that they pay from treating all these poor people. We are economic development in your state. And of course, we're scratching our head. Dick and I are loving this argument. It's a wonderful jury argument. It's just wonderful. Wonderfully well. But truthfully, and you can talk to, I think you have a panelist later on who is the king of the Dr. Death defense, Huber, I believe his name is. But there are also others who have done studies like Michael Cummings and many others who have shown that it's nonsense, absolute nonsense. What we get in the state of Mississippi and all the other states are taxes that are paid by who? The tobacco companies want to make people believe, and they even try to make our judge believe, that the tobacco companies pay those taxes. Tobacco companies don't pay those taxes. The smokers pay those taxes. But what they want is, say if it's $50 million in Mississippi, they want an offset to their damages for the tobacco-related disease, the offset for the $50 million in excise taxes or smokers' cost, if you will, they pay it. And they also want an offset for the money they save us because they kill all our people early. Now, you think of any other area of law where someone gets a credit for the damage that they do or for the offset that they do. I guess I've been a prosecutor all my life. What could happen if we were going to fine somebody in court? So you're hereby fined $10,000 for destroying that building. Wait a minute, Judge. I've added it up. Over the last 20 years, I've paid $250,000 in taxes, so you owe me money. Or how about a corporation who does not have a detrimental effect, who is also taxed? I don't know if you would say the perfume industry has a detrimental effect or not, but it's one that I use, makes people smell nice. They pay lots of taxes. Should we pay them money back? Because, I mean, you see what I'm saying? It's a ridiculous argument, but it's the kind of argument that only the tobacco companies will make.
Can we move on to the next question so we can get...
Can I just respond? It's a ridiculous argument as a jury argument because of the political correctness of it. But as an economic argument, tobacco companies pay more taxes. Each cigarette pack in most states is taxed a lot of money other than the normal taxes that people pay. So you're right, Mike. It's a hard argument to make.
We're welcoming.
In a politically correct jury sense, but from an economic sense, it's not. I just like to say one other thing. I mean, I'm concerned about the tobacco litigation that the attorney generals have brought because I don't know who's next. And if you can do it to tobacco, you can do it to hundreds of other things. Cholesterol food, that's causing heart disease to lots of people in your state. Are you going to go against the dairy farmers next, or the people that manufacture all this high cholesterol food? It's easy to pick on an industry that's politically incorrect for this moment, but you may have let out of the bottle a genie that can create havoc down the line, and I think that's a very interesting problem.
It is interesting, just to respond. Well, I'm very well aware of where I am, but my governor made the very same argument, and we believe this. We can obviously have a disagreement in this scholarly debate, but we believe sincerely that this product, the tobacco product, the cigarette, is the only product, and you've heard this before, that when you use it exactly as intended, that it causes the damage. We don't believe that pepperoni, and we don't believe that meat, and we don't believe that milk that has nutritional benefit has the kind of effect. I'll just give you, just quickly, if you can tell me what the benefit is, sir, to a cigarette, the health benefit or the nutritional benefit of a cigarette is, then I really need that information because we hadn't found it anywhere.
I think there's a lot of psychological benefit to cigarettes that people who feel they're under stress or whatever feel relaxed.
So I guess it's a drug then, a psychological benefit? Oh, it's not a drug. Ooh. Is it a food? No, not a food either.
Let's squeeze in some more questions if we could.
Part of my question got answered because I was going to ask for reactions from some of the panel to what General Moore had said. I guess I have two parts. One, I'd be interested if other panels have a specific reaction, and secondly, I would wonder how different the case of alcohol would be, and that part would go to General.
Well, I have to tell you from the health standpoint, you know, the numbers that I'm seeing on TV, and I'm watching doctors, and I've read the reports about the quote unquote health benefits of the use of wine and other alcohol. I don't know if I agree with that or not. I have seen no documentation that shows me about the health benefits of the use of a cigarette. The numbers comparatively are pretty large. Alcohol deaths in this country range anywhere from 90 to 100,000 people a year from alcohol-related disease, and for instance, cocaine and all the illegal drugs is about 20,000 a year versus 420,000 a year to tobacco. So we think that the cause of action that we have is, and frankly, in my opinion, I don't think it applies to, I don't think it applies to any other product because of the product itself.
Can I get a pledge on behalf of all my other clients that you'll never bring a suit against anyone else on the same basis?
Actually, I've been having calls from Seagram's attorneys and others to, when are you going to file? When are you going to file? You know?
Any other reactions on the?
I agree with Attorney General Moore that tobacco is distinguishable. In addition to the points that he made, in the tobacco case, you have evidence of manipulation of nicotine and you have evidence of intentional fraud. And you just don't have those with pepperoni pizza and dairy products.
I know. Yeah.
You mean they don't manipulate? You mean they don't manipulate the level of milk and cheese? Next question.
Judge Higginbotham, you touched briefly on settlement class actions, but no one really talked much about it. I'd be interested in hearing your perspective and a plaintiff's lawyer's perspective and maybe a professor's perspective on whether the dangers of collusion are greater where you're just certifying in order to settle, whether fairness hearings are enough. Why is it that there's such a controversy about these now?
Do you want to hear a defendant's lawyer too?
Well, the quick answer is that any time you have both parties to the lawsuit that are in agreement, there's obviously a risk and an increased risk of collusion. No one, I think, really seriously contends that there's not that risk. The question is, how do we respond to it appropriately? One of the questions earlier put with regard to the public interest groups and their role in these things, and some of the people who have attacked these settlements, I think that's a very healthy phenomenon. You need people who come in to question and to raise these issues. I don't have any problem with that. Yes, I think there is a risk. Historically, what our numbers show us is approximately 25%, upwards of 25%, someplace the number higher, of all of the class action dispositions were actually settlement classes, meaning that these were cases were settled at the time they were filed. This has been going on since the beginning, if you will. This is not a recent phenomenon. The phenomenon that has brought the settlement class front and center has been its utilization in the mass tort area itself. And I come back again to my emphasis that we look at the substantive area of the law you're talking about. But the answer is yes, and that's a concern. The Rules Committee proposal now mandates a hearing. The question then is, well, yes, that's a concern, but are the courts addressing it? And the answer is, well, locate cases of collusion that in the federal system that have not been smoked out and dealt with. Are the procedural processes adequate? I'm sure there's a risk, but the question is, where are those cases? The cases in which there's the higher risk of this are cases that are being litigated and very forcefully by very able people, by public interest groups, and some of which are self-interested in the traditional American way. Thank you, Steve.
In my opinion, you're going to have classes certified for settlement because you can't have all class actions be tried. So it's not a question whether you have classes for settlement. I think the hard question is whether you ought to be able to certify a class for settlement purposes that you could not certify as a litigation class. And I think that is a very troubling issue.
That's the phenomenon I'm talking about, and that's well over 25% of all class actions that we've had. And I didn't particularize that in answer to Steve's question. I was talking about exactly that group of cases.
But I think that whether or not they exist, the question is whether the class gets appropriate value when there is no threat of litigation.
The safeguard has to be the fairness hearing. The fairness hearing has to be taken seriously, and to prevent the race to the bottom, when there is a lawyer who has a case out there who thinks that they could be getting more than the plaintiff coming in with the proposed settlement is getting, they have to feel free to go to the fairness hearing and object to the settlement, and the court has to take those objections seriously.
One quick point. Under the proposal, the Rules Committee, what it says is that a settlement class it can go forward, but it requires an opt-out right. And what that means is that, from a claimant's perspective, is that when they receive notice of a class certification, they can get out of it. Now, let's assume that you don't do that. We're not going to allow any settlements before certification. Require the class to be certified. Now they're locked in. Now the case is settled. Unless there's some bargain for opt-out right as part of the settlement, that claimant does not have a right to dial out. It has only a right to attack. So that from the standpoint of drawing a line between cases that are settled before certification, cases that are settled afterward, from the claimant's perspective, there's no question but that the claimant is benefited. What's critical to understand about the Rules Committee's proposal is that it insists upon notice, and it insists upon opt-out right, and it does not deal with futures. Once that's on the table and clear, I really don't know of plaintiff lawyers or defendants lawyers who are really have problems with it. The discussion always drifts off into futures, well, inadequate notice, opt-out rights, et cetera, which is a different ballgame and a more difficult subject.
Can I just state that?
Sheila,
I'm sorry. Okay.
I just want to get in one more question because we really need to end this discussion. One fast question.
Walter Olson from the Manhattan Institute. Every couple of days, another large public contract is let. I'm getting back to the AG suits, potentially worth billions of dollars to the contractors. And if this had been about highway resurfacing or some other traditional state government contract, we'd immediately ask two questions. How competitive was the bidding? And second, are they actually going to do the work, or are they going to be able to piggyback on the highway resurfacing efforts of lawyers in other states? Could any of the panelists, but particularly Mr. Moore, comment on, not just in Mississippi, but around the country, how competitive has this process been, and how strong are the safeguards to prevent billions of dollars from going to a lawyer who's piggybacked?
I can again say, when we started our case, one of the things we wanted to stay away from, and it doesn't matter how hard and how many times I say it, we don't have a contingency fee contract in Mississippi. We did that for the sole purpose to keep our eye on the case rather than eye on the lawyers. The debate, it's amazing to me, the debate always
You mean
switches.
the lawyers are being paid on an hourly basis?
If you let me finish, Matt, then you get to respond because you get to write, I don't. In our case, specifically, there's no contingency fee contract. There's none. And let me finish, okay? Thanks. I know you're eager. In our complaint, we have asked the court to award, it's in our complaint from the first day we filed, to award attorney's fees and whatever reasonable amount the court determines should we win our case, but not from the state, from the tobacco companies based on bar standards, et cetera. Now, your question was about the other states. There have been requests for proposals in all the states that I know anything about, where the Attorney General has sent out requests for proposals as to which law firms were interested in being involved in a case like this. Some of them have received 10, 15, some of them have received 5 or 6. Many of them have set panels of people outside their office to go through and make selections of the lawyers. The big determining factors actually have been who is willing to front the cost for this litigation. The guy who files today is obviously much better off than we were in Mississippi because we've probably spent $3 million so far on our case without any compensation going back to the lawyers. So I think there has been public disclosure. In every state I know that the contingency fee contract is a public record. It would be in my state if there was one.
Yeah, and just to follow up, it would be quite surprising if the lawyers at the successful termination of your case asked for a fee based on an hourly basis, even though they had achieved an enormous settlement. They will, in fact, be likely to ask for something related to the size of the settlement, so that you, in fact, have conferred on them a standing that, in effect, gives them likely compensation based on the share of what they get.
Lawyers, I know you don't like this, but lawyers will, if we win, will probably make some money. Yep, they'll probably make some money, but it will be based on, at least in our case, on the work that they do, based on the risks that they took.
I don't understand what the problem is, because there's a client hiring a lawyer. I think the problem generally with fees in class actions is there isn't a client there to supervise the lawyer. If there's an active client, I don't see why it's any more of a problem than how the defense lawyers get paid.
Not to disclose the likely line of attack on these things, and indeed Mississippi is likely to be less attacked on this basis than any other state because it went
Thank you. I got enough tax going on me right now.
But if state number 14 comes aboard, that governor or AG is potentially letting out a $1 billion contract for work which may not involve any actual work, which could be completely piggybacking on what your office and others have done. And again, the controls are in place when this is all done through a highway department. And it's not so clear, especially given the web of political contributions that everyone finds so suspicious about things. It's not clear that the safeguards are already in place for this new form of contracting, which could involve so much more money.
I see your point.
Okay. Thank you very much to all the panelists.